Bonjour, ceux qui sont en présentiel ici. Bonjour à tout le monde en ligne. C'est un réel plaisir de vous accueillir pour cette conférence, puis cette discussion qui va suivre sur le contrôle de l'évitement fiscal par la doctrine de la substance économique aux États-Unis et par la règle générale anti-évitement dans le contexte canadien. On profite de la présence au Québec du professeur Avi-Yonah, qui sera demain le conférencier invité au symposium André Larreau à Québec, donc pour bénéficier de son éclairage sur toute cette question-là, dont il est, entre autres, expert sur ce sujet-là. Dans un premier temps, je vais présenter quelques éléments, quelques grandes lignes des modifications de la règle générale anti-évitement pour mettre la table un peu puis montrer un peu qu'est-ce qui nous amène à discuter aujourd'hui. Bon, c'est une discussion qui a cours depuis très longtemps, mais de remettre ça aujourd'hui puis de discuter de la substance économique. Par la suite, il y aura une allocution du professeur Avi-Yonah. Il suivra une discussion avec deux experts qui s'ajouteront, Rémi Gagnon et Jinyan. Permettez-moi de transférer en anglais. La conférence se tiendra en anglais pour présenter les conférenciers et pour débuter la conférence. Pour les gens en ligne, on a fait appel on a appliqué les services de Zoom pour la traduction simultanée en sous-titres. Donc, assurez-vous d'activer les sous-titres pour voir la traduction. On n'est pas garant de la qualité de cette traduction-là. On s'en remet à Zoom, on fait l'expérience, on verra qu'est-ce qui va ressortir de cette expérience-là. Donc d'abord, permettez-moi de vous présenter nos invités d'aujourd'hui. Professeur Reuven Avi-Yonah is the Irwin I. Cohn Professor of Law at the University of Michigan. He specializes in corporate and international taxation and has served as a consultant to the U.S. Department of Treasury and the OECD on tax competition. Professor Avi-Yonah is a member of the American Law Institute, a fellow of the American Bar Foundation and the American College of Tax Counsel, and an international research fellow at Oxford University Center for Business Taxation. It is likely that you came across some of his writings because he has published more than 250 books and articles. Thank you for joining us today at the University de Sherbrooke. Jinyan is a professor of tax law and former interim dean of Osgoode Law School, York University. She is currently the co-director of the LLM tax program and academic director, professional graduate studies program. Professor Lee has authored, co-authored, and co-edited numerous articles and books. She is co-editor of Current Tax Reading in the Canadian Tax Journal and a member of the editorial board of World Tax Journal. Thank you very much for your presence today. Also, we have with us Rémi Gagnon. Rémi is a senior advisor of the Department of Finance Canada Tax Policy Branch. Prior to his current position, Rémi practiced Canadian and U.S. tax law at major corporate law firms in Montreal and New York City, where he focused on complex cross-border investments and transactions, mergers and acquisitions, and capital market transactions. Thank you very much for having accepted to be with us today. So I will provide a brief overview of the modification that were adopted to our general anti-avoidance rule, just to set the stage for the discussion. As you probably all know, the GAR was introduced in 1988 to counter tax planning schemes that reduce tax, but that also constitute an abuse of the law. The conditions for its application is we have to have a tax benefit, an avoidance transaction or series of transactions, a transaction or a series that results directly or indirectly in a misuse or abuse of the provisions of the law separately or read as a whole. Before the recent amendments, the GAR application resulted in the payment of the tax that would have been due in the absence of the abusive transaction or series, plus interest, but that was the only consequence. Let's turn to the recent modifications that have changed some of these conditions. First of all, a preamble was adopted and was incorporated just before the section 245. Basically, what it says is that the general anti-avoidance rule applies to deny the tax benefit of avoidance transactions that result directly or indirectly either in a misuse of provisions of the Act or an abuse having regard to those provisions read as a whole, while not preventing taxpayers from obtaining tax benefits contemplated by Parliament. And also, the GAR strikes a balance between the protection of the tax base and the fairness of the tax system, and the need for certainty for the taxpayers to plan their affairs. So we'll talk a little bit more about that, about the impact of the preamble during the discussion. For the avoidance transaction, the definition now states that unless it may reasonably be considered that obtaining the tax benefit is not one of the main purposes for undertaking or arranging a transaction, the transaction is an avoidance transaction if the transaction results directly or indirectly in a tax benefit. So the test is not one of the main purposes. So the obtaining of tax benefits should not be one of the main purposes. Now turning to the inclusion of economic substance in the GAR with those modifications, it has been included in the analysis of the abuse or misuse. So when we go through the analysis of this, what the new subsection 4.1 says is that if an avoidance transaction is significantly lacking in economic substance, this is an important consideration that tends to indicate that the transaction results in a misuse or an abuse. So it is an indicator that we have to consider that may lead to consider that there is an abuse or misuse, but it's just one factor to consider, among other things. And how do we know that something is lacking economic substance? Well, 4.2 says if the opportunity for gain and the risk remains unchanged for the taxpayer, it may be something that shows that there is a lack of economic substance to the transaction. Also, it is reasonable to conclude that at the time of the transaction, the expected value of the tax benefit exceeded the expected non-tax economic return. So it's another factor that would indicate a lack of economic substance. And finally, it is reasonable to conclude that the entire or almost entire purpose for undertaking or arranging the transaction or series was to benefit, to obtain the tax benefit. So this is some of the indicator, the new indicator that we have to work with in the GAR in the Income Tax Act. Finally, a brief note, there was no penalty before. Now we have a penalty that may be applicable. So if GAR applies for a transaction that was not previously disclosed under the disclosure, the mandatory disclosure rules, there will be a penalty that will apply, 25%, summarizing all this on the tax payable because of the application of the GAR. So this is the really basic things from the GAR, just to start the conversation. But now I will turn it to Professor Avi-Yonah to talk to you about the US context, so the economic substance doctrine in the US tax law.
Thank you very much. It's a pleasure to be here. I love coming to Montreal, but I've never been to Sherbrooke, so here's my opportunity. So I want to talk a little bit about economic substance in the US. And this is a codified doctrine that is in 2010, Congress decided to put it as a provision of the Internal Revenue Code, section 77010. And so now you have a text. But the problem is that when they did that, they said, well, we don't intend to change the pre-codification meaning of the doctrine. And the doctrine only applies when it is, quote, relevant, unquote, and relevance is determined based on the pre-codification. So basically, they didn't really do very much. The one thing that they did, and the reason it was a revenue raiser, was, as we will discuss in a moment, there were two prongs to the doctrine, and some courts said that you only have to satisfy one, and they said, no, you have to satisfy both. And that's why they said it raises revenue. And as usual in the US, all provisions are included or not included based on what the revenue impact is. So then you have to go back. And when you go back, you go all the way back to 1935. This is where things really started. That's Gregory v. Helvering, most famous US tax law case of all time, at least most commonly cited one. And that was a case involving what was claimed to be a reorganization transaction, that is a tax-free reshuffling of corporate interests, except that the only reason to do that was to avoid the double tax on corporations and dividends. And so when it got to Judge Hand in the Second Circuit, he said that, and now I'm quoting a little bit because he was a wonderful writer, if what was done, what was intended by the section, it is of no consequence that it was all an elaborate scheme to get rid of income taxes. It certainly was. Nevertheless, it does not follow that Congress meant to cover such a transaction, nor even though the fact answered the dictionary definition of each term used in the statutory definition. It is quite true that as the articulation of a statute increases, the room for interpretation must contract. But the meaning of a sentence may be more than the separate words, as a melody is more than the notes, and no degree of particularity can ever obviate recourse to the setting in which they all appear, in which they all collectively create. I love this writing. It's just such a good writer. And then he went to the Supreme Court, who were not such good writers, but they basically said the question for determination is whether what was done apart from the tax motives was the thing that the statute intended. So you'll notice that this all really hinges on what Congress's purpose is, just like the guard that we just heard refers to Parliament's purpose here in Canada. And that was true for a long period of time. In fact, for 40 years, until 1978. There were other cases at the same time, and they all emphasized the same thing, which is, was what was done what Congress intended when they wrote the statute. And in my opinion, that's not economic substance, or at least not the way economic substance is understood now in the United States, and that's the heart of the problem. Because economic substance doctrine stems from a 1978 Supreme Court case called Frank Lyon. And in that case, the court says, not referring to anything having to do with congressional purpose, they said what matters is whether the taxpayer had a non-tax reason for the transaction. And in that case, they said, yeah, they had a non-tax reason, so therefore the transaction is fine. But the emphasis is entirely on the taxpayer's purpose. And the taxpayer purpose, to be fair, also appears in Gregory. But what they said there was, it was not Congress's purpose to include transaction whose only purpose was reduction of taxes. But the emphasis is entirely on congressional purpose, not on the taxpayer purpose. In Frank Lyon, there's no mention at all of congressional purpose. And it's entirely about what the taxpayer purpose. And then, lower courts took hold of that, and gradually in the years between 1978 and 2010, there was a lot of case law developing the economic substance doctrine. And the way the economic substance doctrine now stands in the United States is that it has these two prongs, the subjective prong and the objective prong. The subjective prong, as the name implies, asks the question, did the taxpayer subjectively have an intent other than tax minimization when they entered into this transaction? And that's basically a question of whether the court believes the taxpayer. That is, invariably, the taxpayer will say, oh, of course, I didn't just mean to minimize taxes. And usually they will also produce some kind of affidavit, sometimes even contemporaneous affidavit that says, oh, this is what I mean when I enter into this transaction. Especially in tax shelters, you see this kind of affidavit explicitly, and they always cite something that is not a U.S. tax motivated, and it's usually bogus. But it's a question of credibility. And then there's a question of whether objectively there was a profit potential from the transaction. And there, that's supposed to be an objective question, except that I'll give you some examples in a moment that shows that it's not so simple. Because you can, in fact, insert some profit potential into transactions that are not really about that profit, except that under some unusual and rare circumstances, there will be a profit, which is not what they intended. So let me give you a few examples of transactions that at least arguably are okay under the economic substance doctrine, and I think they're problematic. So the first one is a case called Compaq, and because it was a corporate tax shelter, there were two identical cases with the same facts, two different corporations, because the way these things work is that usually one of the big four develops a shelter and then sells them to various clients. In this case, people who were in what's called a corporation that were in what's called an excess foreign tax credit position, namely that they had more foreign taxes that they could credit because the limit is the American tax rate, which was back then 35%, now 21%. Okay, so what happened in Compaq was that Compaq, like most American corporations before 2017, had foreign income that was subject to low foreign taxes, a lot of it. And they couldn't bring it back because then they would have to pay tax at 35%. That's how it worked before 2017. And they wanted to give it back. So they wanted to create artificially foreign tax credit without actually having to bear the burden of a foreign tax. So what did they do? Royal Dutch Shell is, as you probably know, a big Netherlands-based multinational, and it issues what's called American Depositary Receipts, which is basically shares traded on the American stock exchanges. And some of them were held by tax exempts, which is normal, because tax exempts hold a lot of equities. So the problem is that tax exempts, of course, can't benefit from foreign tax credit because they're tax exempt, so there's nothing. So Compaq comes to this tax exempt, and they say, look, we know that Shell is about to pay a dividend, and this dividend will be subject to a withholding tax in the Netherlands. But you can't benefit from foreign tax credit, so why don't you sell us the shares and we'll get the dividend, and then we'll sell them back to you. So Compaq buys the shares from the tax exempt for $100. I mean, I'm just making numbers up, but and then they get a dividend of 20, and then they sell it back for 80 because ex-dividend the stock is worth only 80 because they got the 20 already. So pretty obviously there's no profit potential here, right? They paid 100 and they got back 100. 20 in forms of the dividend, the 18 in terms of what they sold it for. So where's the profit potential? Well, there was a 15%, that is $3 Dutch withholding tax on the 20 under the terms of the treaty because it's a portfolio dividend. And that 3 was born pretty clearly not by Compaq because they paid 100 and they got back 100. So they didn't bear the burden of the tax. Who knows who bore the burden of the tax? Exactly. But in any case, it was clearly not them. But then they claim foreign tax credit for this 3. So it goes to the court, and the court says, what was the profit potential? For tax purposes, when they got the 20 of dividend, they had to declare not 20, but 23. Because the way the foreign tax credit works is that when you get foreign income that has a tax on it, you gross it up, as they say. You add the amount of the tax, you include that in income, you calculate the tax, and then you take the credit. So they said, okay, you paid out 100, and you got back 103. So the 3, which is the Dutch tax, is the profit potential. Taxpayer wins twice in 2 different circuit courts. So that's the objective prong. Second example is a transaction that I actually was involved in litigating called FLIP, the Foreign Leverage Investment Partnership. Was designed by KPMG, and then it migrated to PwC and some of the other ones. So the way this works, it's a little bit more complicated, but bear with me. You have a U.S. corporation that has a capital gain because they sold something, and they would like not to have to pay tax on this capital gain. So what they do is that they approach UBS, the Union Bank of Switzerland, which is a counterparty to a lot of tax shelters, and they come up with the following scheme. So they set up, or the promoter sets up, a foreign corporation that invests in the shares of UBS. A certain amount. And then the same shares get redeemed. That is, they invest and then they get bought back. So that's just circular. At the same time, when UBS redeems its shares from the foreign company, the taxpayer invests exactly the same amount in UBS. And why is that relevant? Well, because the way the American tax law works, the question is when you have a redemption, is a redemption a dividend or is it a capital gain transaction? That is, does it qualify for the lower capital gains rate or is it taxable as a dividend? And the rule basically is that if you haven't reduced your share ownership, it's a dividend. That is, you have to meaningfully reduce your ownership below what it used to be. Because obviously, for example, if you're a single shareholder of a corporation and it buys back some of your shares, you're 100% before, you're 100% later, so you haven't reduced anything, and that's just a dividend. There's no sale of shares involved, even though it looks like a sale of shares. Okay, so what happened here? Well, you test this redemption, this foreign redemption by UBS, to see whether it's a dividend or not. And here, there's something called the attribution rules. That is, you attribute from one shareholder to another. And the key element that I didn't mention was that the taxpayer had an option to buy the shares of the foreign corporation that did the redemption. When you have an option under the attribution, those shares get attributed to you. And because the taxpayer invested exactly the same amount as the shares that were redeemed, under attribution, there was no reduction in ownership. Since there was no reduction in ownership, it's a dividend. Now, what's the problem? That dividend goes to a foreign corporation, so therefore, who cares? There's no tax liability. But now, the question is, well, what becomes from the basis that the foreign corporation had in its shares? Okay, well, basis can't get lost. So then you say, well, okay, where does this basis go? It has to go to the other shares, the new shares. And suddenly you have shares with a double basis, you sell them, you get a capital loss, and bingo, you use that. Now, again, this was never litigated because the IRS was worried that they might lose because it was consistent with all the... And here's the issue. Where was the profit potential? Well, the way this option that they had worked was it was written in such a way that if UBS performed extraordinarily well in a very short period of time, then you could have a 40% profit potential. But the likelihood of that was basically zero. So you put in an artificial profit potential into the transaction, and you say, subjectively, that's what I intended, and objectively, here's the profit potential, you win. So the IRS settled these cases very generously, so no penalties, and they gave them some of the tax benefits. So basically, it was never litigated. Enough. I mean, there are more examples, but let me just give these two. So if you apply the economic substance doctrine to this, it works because there's subjectively and objectively. Now, I think this is all wrong, but that's what the court decided. Certainly in Compact, that's what the court decided. What happens if you apply the old test, congressional purpose? Well, clearly, the point of the foreign tax credit is to prevent double taxation. There is no double taxation in Compact because they paid 100 and they got back 100. So where's the double taxation? They didn't bear the burden of the tax. It can be shown that they didn't bear the burden of the tax. So therefore, under congressional purpose, they shouldn't have gotten away with it. And even more so in the flip case, because there it's obvious what the purpose of the... So the classic example is, let's say you have a husband and a wife, and they each own 50% of a corporation, and they're both taxable individuals. And then the husband gets redeemed 100%. So then you say, okay, is this a capital gain transaction or is it a dividend? Now, as far as the husband is concerned, he sold everything. So, you know, you're supposed to get your basis back. But the assumption under the attribution rule is that the husband and wife has the same economic interest. And since the wife is now the 100% owner of the same corporation, those shares get attributed to the husband. Therefore, there was no reduction in ownership. Therefore, so it's all about taxable U.S. individuals. To take this rule and apply it to a foreign corporation that doesn't care at all whether there's a dividend or not is obviously not what Congress intended. It's a much more clear-cut example than, in my opinion, than the first one. And so clearly, if you apply the old test, that wouldn't work. And by and large, you know, the problem now is that the American courts have become more and more textualist. So what does textualism mean in this context? It just means that they follow the words of the statute. And there's this case now, Liberty Global, which is kind of the key test case. Liberty Global is a very, very aggressive taxpayer, and they've engaged in numerous tax shelters around the passage of the 2017 tax reform, and a couple of them are now in litigation. And what's interesting is that they say about this transaction that they engage in, which I'm not going to go into the detail, that it fails the economic substance doctrine. They explicitly says that we had no subjective purpose, we had no objective purpose. It's all about tax. But they say the economic substance doctrine cannot be applied as a legal matter when the words of the statute are unambiguous, because that misrepresents the role of the court. The court is supposed to, that's how textualist judges think. The role of the court is to implement the statute as written. If there's a problem, Congress should fix it. And the famous, example is from Judge Shatson in the Sixth Circuit, who's also a very good writer, and he says, well, the Roman Emperor Caligula used to enact tax statutes and hang them up so high that nobody could read them, and then he could collect the taxes. And that's not the way it's supposed to work. If one of you remembers from the Harry Potter movie, there was the same thing where they, they hang the new statutes very, very high, so it was impossible to read them. So that's where that is coming from. So basically, so that's not how it's supposed to be. The taxpayers are entitled to rely on the words of the statute as written, at least where they're unambiguous, and therefore it's okay to follow. And the problem is that basically every tax shelter ever devised follows the words of the statute, precisely. So if you don't ask what the words mean, if you don't use the learned hand test of, even though it means a dictionary definition, you have to look at the context and you have to look at what Congress intended. So what's interesting about Liberty Global is that this was a district judge in Colorado, and he actually says, what economic substance doctrine really means is that we should look at the purpose of Congress, which is not my opinion of what it means, but that's what he said. And it's now an appeal, and we'll see what happens. But the general tendency is for courts to be more and more textualist, and that means that more and more shelters will succeed. Now, there's one potential ray of hope, in my opinion, and that's this business about ambiguity. Because the truth is that there are lots of words that are ambiguous. Now, some shelters rely on things like these ones that I mentioned, Liberty Global, on effective dates and stuff like that. It's not ambiguous. I mean, if the statute changes of such and such a date, but the key word in Gregory was reorganization. And even though reorganization is defined, it's still not entirely clear what that word means in this context. In Net, which is another famous Supreme Court case, the keyword was interest, and that's definitely not defined in the code. So what does that mean? And now we have this most recent decision of the Supreme Court called Loper-Bright, which says that basically courts should not defer to agency interpretations of statutes, period. Doesn't matter what the IRS says or any other agency, unless there's an explicit delegation and so on. But in general, there's no deference anymore to what an agency, the way an agency interprets a statute. Instead, courts should look at the text of the statute and interpret it in such a way as to get to the best meaning, and every statute has a best meaning, and it's up to courts to decide what that is. Okay, so then the question is, how do you decide what the best meaning is, given that you can't, you can't go to the IRS and ask, or the regulations, you have to ask what the best meaning is of the words of the statute. And I think if the words are ambiguous, there's kind of an opening for a textualist judge to say, well, let's take a look at what they meant, maybe. Or, as in the more recent Moore case, let's take a look at what the practical consequences are of if we hold this way, because what happened in Moore, this was a constitutional case about what the meaning of the word income is, and whether it means income, realized income or not. And the majority said explicitly, if we decide that income means realized income, the government will go so bankrupt, so we will not decide it that way. They say that in the decision. If they start thinking that way, then I think we have a chance. Thanks.
Thank you very much. If you want to join me for the discussion. Thank you very much for this very interesting presentation. This will launch our discussion. I know Jinyan was taking notes.
Yes.
Yeah, exactly. Yes. So, is it okay if I do it like this? Because okay, so thank you very much. We will have a lot to talk about. We We have concentrated our discussion around a few themes, but maybe just to launch the discussion, I would ask, from what we've heard, from what is the economic substance doctrine in the US, what we have in Canada with GAR, and now some kind of economic substance test within the GAR, do we see meaningful parallels or key differences between the US and the Canadian approach? Is the US experience helpful for us? Maybe it is, maybe it is not. In thinking about our GAR and the recent modification, maybe I will start with you, Jinyan.
Okay. Well, I'd like to thank you, Lyne, for involving me and being together with Rémi and Reuven. And thank you all for being here. Otherwise, it will be a different experience, I have to say. So it's lovely to see you guys in the room. This topic is a huge, huge one, so I hope you indulge me by laying out some of the basics. Then we can talk about the sophisticated solutions. Tax avoidance is a complex problem because it involves a statutory interpretation. We all know taxation law is statutory based. So the question is, what does the law say? Does this provision apply to the taxpayer? The first one is a statutory interpretation question, a legal question. The second one is a factual determination. What did the taxpayer do? Is this transaction what the law refers to? So there are choices. In terms of the meaning of the law, Reuven alluded to, do we look at just the words, or do we look at the purpose and intention of the legislature? So two choices. Letter of the law or the spirit of the law, in simple terms. How do we understand taxpayers' transactions? Again, multiple ways of answering that question. Looking at the legal form, what the taxpayer did, or look at the purpose of the taxpayer. Or we look at the substance, not the legal substance, but economic, commercial, business substance of the transaction. And so there is no straightforward answers to any of these questions. And then Reuven alluded to the notion of ambiguity. You probably know that the Income War Tax Act in 1917 had 4 pages. And now the act is written with about 1.2, 1.3 million words. And words like interest, cost, capital, corporate residency, corporate control, fundamental terms, undefined. So ambiguities all over the statute. So then the next big challenge in tax avoidance cases, again, is alluded to by Reuven, is how do we identify the law is ambiguous? How deep do we look at? Do we take the face value of the words? Dictionary definition will do, or do we look deeper? Look at the context, look at the history, look at the intention. Again, there's no straightforward answers to this, but that's what the GAR is all about, in my view. GAR is to tell the judges how to interpret the law. Is it the letter of the law or the spirit and context of the law? And how judges judge the transactions, look at the purpose, look at the reality of the substance. And so the GAR, in my view, was a deliberate intention on the part of the government to tell judges how to do the judge's job. Because in Parliament's view, judges were not doing a good enough job. That's why the GAR was there to tell them how to read the transactions, how to read the legislation. So then every country's tax system has similar challenges. And I just read 43 countries' summary report on the GAR in their country, and I learned there are a huge variety of solutions to the tax avoidance problem. So US has the ESD doctrine, Canada has the GAR, and Lyne asks us whether we can learn anything from the US. I have to admit, I used to be a fan, admirer of the US ESD. No more. No more. The reason is that if we just look at the taxpayer's transactions without looking at the law, what the law is saying, what is intended to say, what is the meaning intended by the legislature, we're assuming, we're attributing intention and purpose on the part of the legislature. So the ESD only look at the purpose of the taxpayer, US ESD, and looking at the economic position, whether that's changed by the transaction. Looking at one side of the system, and that create asymmetrical interpretation, interpreting the taxpayer's transaction one way by looking at the purpose, but not attributing the purpose or taking a purposive approach to reading the law. There are two sides to the game, transaction and legislation. So the US is asymmetrical based on the judge's understanding and application of the ESD. So in that sense, the Canadian GAR is better in design. The Canadian GAR requires judges to look at the transactions, looking at the purpose in defining avoidance transaction. Now with the 2024 amendment, ask the judges. Whether the judges will do it or not is a separate question. The Parliament, at least through the economic substance test, asking judges to turn their attention to the substance of the transactions, not just the form, not just the broader purpose. So at least by design, the Canadian GAR is much better, in my view. So, but I have to say we can learn something from the US experience in terms of determining, how to actually assess economic substance. The Canadian design, in my view, again, in the new GAR, is very mechanical, too limited. The American ESD is better in design on that side, on one leg of the two-leg stool. So we could learn something. I was a bit surprised finance came up with a new GAR economic substance to be so mechanical, so limited, largely irrelevant, I would say. We'll get back to it later. Yeah. So the US ESD design on that thing is better than ours.
Yeah. Thank you, Jinyan. Rémi?
Yeah, sure. So maybe just a usual disclaimer. So I'm currently at finance, but I'm here in my personal capacity, not to speak on behalf of finance. So if you have complaints about the GAR, I'm not I'm not the right person today. So I think when you look at the from a Canadian perspective, it's important to put economic substance in context when we look at it from a Canadian perspective, because so Reuven talked a lot about the economic substance doctrine, but from a Canadian perspective, when you look at the US, there are other doctrines that incorporate economic substance principles, or at least that's how we would look at it from a Canadian perspective. For instance, in Canada, the tax system is accessory. So usually you take the private law, the legal form as given, and then you just apply the tax rules to that. So if you take financial instruments, what is debt, let's say under Quebec law? Typically, well, the Canadian tax system will say, well, that's debt for tax purposes. That's not necessarily the case in the US. So in the US, there's a sort of tax-specific meaning to what is debt. And so you can end up in a situation where what is debt under New York law is not debt for US tax purposes. And that can be, in practice, pretty powerful, because when I was practicing in the US, like that, sometimes it would keep me up at night if something was debt or equity. But in Canada, that's not the approach we've taken with economic substance, because there were some statements made in connection with the GAR amendments where Canada basically said this is not the version of economic substance that the GAR amendments are basically trying to achieve. So when we look at the US experience, it's as if the US has many tools in its economic substance toolbox, but Canada has a more limited approach to its economic substance.
Okay, thank you. Reuven, anything to add?
I mean, the bottom line of what I wrote about this, but I don't think there's any chances that we should adopt a Canadian-style GAR. That was my conclusion in that particular piece. That's not going to happen. I mean, the general American approach has always been, this creates too much uncertainty. Now, we do have one experience with it, which shows, in my opinion, that it doesn't create too much uncertainty, but that also is somewhat problematic now, because back in 1991, I think we adopted a partnership anti-abuse rule that says any partnership-related transaction that is inconsistent with, and it actually uses these words, the spirit of subchapter K, which is the partnership provisions of the code, can be challenged by the IRS. Now, at the time, this was hugely controversial, and they put in some examples of things that are not inconsistent with the spirit, and so on and so forth. But since then, it doesn't seem to have created too many problems, and my reading of the Canadian GAR is that it also hasn't created too many problems in terms of uncertainty. And it's the same now with the primary purpose test in treaties, that people have said it creates too much uncertainty. And again, I'm not sure that that's an issue. But there is a problem now with the American Partnership Anti-Abuse Rule, because it's just a regulation. It's nowhere in the statute. And under Loper Wright, the case that I mentioned, the IRS doesn't have the authority to define what the spirit of subchapter K is without anything more. So I think that at the very least, I would hope that Congress will codify that. But again, I don't think they're going to.
Have they ever considered with other countries that have a GAR
Oh.
and consider having it in the United States?
The Americans have
What
never
a great
looked, never
question.
look at what other countries do is the problem. Yes, I wish they would. I mean, look, I mean, I can just quote one thing that was said in the American literature recently, which is that allowing, so there's been a recent procedural change. Until recently, a regular revenue agent couldn't assert the economic substance doctrine. They had to get approval by a supervisor in Washington. And that was changed recently by saying, no, any revenue agent can assert it. It's just if they want to assert penalties, they have to go to the supervisor. But people have criticized that and say, oh, now, I mean, this creates too much uncertainty. Every revenue agent will do this going forward, and this is a terrible thing. And they say this has now become like a GAR. And as you know already, that I don't think it's like a GAR, even if, and B, Jinyan, you can talk more about that, but in most countries that I'm familiar with, there are procedural steps in order to assert a GAR. Sometimes really high-level steps in order to assert a GAR. Not any revenue agent can just assert a GAR. And I think that is appropriate, and I think it would have been appropriate in the US too.
Oh, thank you. Thank you.
So maybe on the point of certainty or uncertainty, I am struggling sometimes when people use the word certainty or uncertainty in the area of tax avoidance, because the nature of the issue, the question is uncertain. There are no certain simple answers to complex problems I laid out. How to understand transactions. If, say, a transaction, a corporation is a person for tax law purposes, but what is a corporation? Piece of paper or a company operating a lot of substantive businesses. They're all corporate vehicles, legal fictions. So one of the tax shelters involve corporate forms, multiple jurisdictions, different countries' laws, how to treat attribution rules, who owns what. I mean, these are fundamental questions. There are no legislative answers to any of it. Who is a person? What is income? Who owns it? Where does that person live or is a resident? Whose capital is it? All of these fundamental questions, there are no answers. So expecting the GAR or expecting tax law to provide certainty is just a fantastic dream. It's not really legally possible. So, but it doesn't mean uncertainty is not an issue. So Reuven mentioned procedures to control. Like in Canada, there's a national GAR committee before the GAR can be invoked. It's not every tax auditor can just play the card, the nuclear weapon of the GAR, and assessing every taxpayer from hindsight when the deal has been done, capital has been invested, and business structures have been put in place. So that will create a lot of uncertainty. But if we look at the Canadian GAR cases, these are not really the ordinary business transaction. These are fancy tax shelter involving different legal forms, different jurisdictions, a lot of helpers, banks, and other multinational corporations. So alleging certainty, to me, is not a very sincere part of the debate about the GAR. Certainty in the Canadian system, Lyne laid out, there are serious steps. You have to identify a tax benefit. And the primary, one of the main purposes is to gain the tax benefit. And then the abuse and misuse test. purpose, rationale of the provision, and then you assess that with the outcome. Very serious legal steps. And so to me, providing legal steps, procedures to ensure certainty is better than just claiming all the ambiguities on the face of the law should be interpreted for the benefit of the taxpayer. That's the kind of certainty some people claim that the tax law should give. That's the previous system before the GAR. But now, because the tax system is such a complex system reflecting compromises Canadians have made since 1917, it's a statute of complex conflict of interest and values and competing interest between the individual's interest to minimize tax and the public interest in getting enough money to pay for public spending. So asking for certainty when there are so many complex conflicts to be resolved, it's just not realistic in my view.
And I will get back to you because I want to hear you about how about the preamble that basically puts uncertainty in there. But I'll be right back. I want to ask Rémi, what do you think about those arguments about uncertainty, and can it be balanced with fairness? Does the interpretation of GAR provide more certainty, has provided more certainty in the past or not? What are your thoughts on that?
Well, I think if you look at in the context of economic substance, and you look at the experience the US has, and when I look back at my time as a practitioner, I do think that there's a lot of uncertainty created by economic substance in the US. I think as a practitioner, it's really hard to know when it applies. We're talking about the Gregory case earlier, but basically nothing economic happens in Gregory. You have basically a corporate distribution to a sole shareholder. And a sole shareholder doesn't become rich or poor by virtue of a corporate distribution. It's just the legal ownership changes. And so what you need is really, as Reuven was saying, is more a principled way of determining legislative intent. And in the US, historically, economic substance has been a poor proxy for that intent. But interestingly, even though economic substance is, at least from a practitioner perspective, I think creates a lot of uncertainty, in the US, somehow like the tax system remains fairly workable. And I think the answer, I think in my mind, of why that is, it's because in the US, there's a huge volume of administrative guidance and regulations. And so what do I mean by a huge volume? So in Canada, right, if you look at, I see an Income Tax Act over there, at the end, there are like the regulations. And if you count the pages, it's about like 500 pages in Canada. In the US tax regulations are about 80,000 pages. So you heard that correctly, like 80,000. So
talking about certainty.
Yes. And so, I remember when I was, like, we have students here. I remember when I was a student and you're like Canadian tax and the income tax is thick. There's a lot to learn. It's hard. At times you can feel overwhelmed. But all I can tell you is it could be worse. But this body of administrative guidance in the US, I think, gives a lot of certainty, or at least that, for instance, if you have, like Reuven was talking about example and the partnership anti-abuse rule, there is an example there, and taxpayers can look at those examples, and if you fit within that fact pattern, that rule won't apply. So I think the sheer size of administrative guidance in the US has basically been able to counterbalance the uncertainty created by economic substance. So now if we translate that to Canada, we don't know how it will be interpreted, but in a situation where, it's as uncertain as in the US, maybe you could think as Canada as maybe we'll need more administrative guidance to make the whole thing workable.
Okay.
But let me give you one example which builds on what I've said about why the American tax law is so long. And here it is. And I think it is longer than the Canadian income tax.
It is.
So we described compact, right? So they did this trick with getting the foreign tax credit for a dividend, for a tax on a dividend they didn't burden board of. Okay. And part of the point of the transaction was that the buying and the selling of the shares took place within minutes. So there was no economic risk that the value of Royal Dutch shares would drop while Compact owned them. And so that's part of the issue. Okay. So Congress looks at this in 2010, and the same enactment where they codified economic substance, they said, we're going to put in a rule that in order to get the foreign tax credit on withholding on a dividend, you have to hold it 45 days before and 45 days after the dividend received that. So that kills that particular transaction because too much risk. So then what taxpayers did is that they did exactly the same thing, except now it was withholding on interest and royalties. So Congress had to go again and change Section 901 again in order to apply to interest and royalties. And that's how the game works.
Yes.
Every time they discover what they think of as a loophole, this is why I don't think that it's realistic for Judge Sutton to say, well, Congress should fix it. They do, and then taxpayers are much faster, and they come up with a new variation, et cetera, et cetera, et cetera. And in the end, we get, 5,800 pages of the law, which, is full of internal contradictions, of course.
Can I make a comment?
Yes, sure.
Sorry. It's a typical, not typical, but it's found in many countries where the judges, including the Canadian Supreme Court, would rely on the implied exclusion doctrine, which is the point Reuven made. If a position or argument is not explicitly stated in the law, then it's permitted. So in Cawthorne, the Supreme Court of Canada said that's no longer relevant under the GAR because otherwise you need to see words in the statute, then the GAR is useless. But in Outer Energy, if you read it carefully, you see the traces of that doctrine coming into play in the reasoning of the majority. And the solution to the tax avoidance problem through legislative clarity is difficult because in Canada, we have the GAR, but the Department of Finance still introducing specific anti-avoidance rule to shut down a structure because it took a long time for the GAR to work through the system. And we have counterparts to the transactions you talk about, like in PAC. It's a we call it foreign tax credit generator scheme. Yeah, we call it. And we shut it down through legislative fix, requiring economic reality test in Section 126, sub 4 or 4.1. And the other is, surplus stripping. How do you manage? So the phenomenon can be seen in other countries. The solution could be different. Yeah.
But you have one advantage over us, and other countries do too. You have a parliamentary system, which means the government decides and Parliament passes it. In the US, in order to pass tax legislation, you need the same party to control the White House and both houses of Congress, because there's never any, for years now, there hasn't been any bipartisan tax legislation. I think the last time anything like that happened was in the 1980s. So in 1986, the big Tax Reform Act was passed on a bipartisan basis. And then you got the Technical Correction Act of 1987 and the Technical Correction Act of 1988. Every time they discovered a problem, they fixed it by subsequent legislation. But by 1993, with Clinton, it was, partisan, and with Bush, it was part. And every single piece of tax legislation after that can only be passed by reconciliation on a partisan basis. And that means between 2017 and 2025 now, it's 8 years with no tax legislation possible because the same party did not control all three. And it doesn't happen that frequently, which means that even if there are egregious errors, they cannot be fixed. Again, that's, in my opinion, a rationale for having a GAR, because then at least judges can do something about these kind of things where there are obvious technical glitches, which always happen, especially when you rush string 2, like now they say by July 4 we'll have a tax law. It's terrible.
Yeah, it's a big, beautiful thing.
One big, beautiful bill act, that's what it's called.
Jinyan, I want to jump with you with the preamble, because two things I would like to address regarding the preamble. You talked about the implied purpose, the analysis of the implied purpose. Does that change with the preamble that states that it is a tax benefit? It does not prevent from benefiting from something in the Tax Act that was contemplated by Parliament? Does that change something? And will that change something in the interpretation?
I'm glad you gave me a framing for my... the preamble, maybe just stick to the preamble, whether it's actually going to be useful. But the the preamble did do a couple of things to me, and I wrote a paper. You're happy to share it with the audience. Okay. The preamble in the Canadian legislative landscape, preambles are used in some statutes. And the Canadian Income Tax Act is unique. It doesn't have a preamble because it's too complex to state anything on the top, what this statute is. But the GAR, the provision has a preamble now. So why Parliament bothered to put a preamble in? So there must be a reason. Parliamentary supremacy doctrine in Canada, Parliament could do no wrong. Parliament must have a reason. So it's possible that Parliament wants to clarify the job of the judge. When a judge apply the tax law provisions to clever, innovative, creative tax planning transactions, how do they apply the law to the facts? So the preamble now says that parliamentary contemplation of parliamentary supremacy, if a tax benefit is clearly intended by Parliament, courts in the Canadian system keep your hands off, don't second judge Parliament's intentions, so Parliament intention carries. And to me, that means tax expenditure provisions, tax subsidy provisions, those are clearly intended by Parliament and taxpayer can benefit from, like RSP. The court seems to use RSP savings as an example. RSP is a tax expenditure. This is not the debt versus equity kind of problem, totally different animal, different in nature. So that is clear. And then Parliament, through the preamble, requires judges to consider a balancing, do the balancing act openly, explicitly. Balancing fairness of the system, I call it fairness for all, against certainty, fairness for one. Because it's the taxpayer before the judge want to have fairness by getting the tax result they planned to get, by playing on the game of another game, the doctrine of ambiguity. The words are not clear, so the taxpayer can plan and gain the benefit. So now, through the preamble, Parliament says, gee, wait a minute, don't jump to the certainty preference. Consider fairness of the system. Considering the integrity of the system, protecting the tax base. Are you putting the taxpayers not in front of you, but the system is supposed to balance, raising revenue to do public jobs, raising revenue to pay redistribution and pay public expenditures. So fairness, I wrote a paper on the preamble focusing on the fairness because the Canadian jurisprudence in GAR is very clear. Fairness is moral judgment is outside the GAR. It's not a legal test. So what does fairness mean? So through my research with a team of my students, we concluded fairness in the GAR preamble means the legal meaning of fairness, which is really a very serious, rigorous examination of the policy and purpose of the Parliament in enacting a rule. Not right or wrong in a moral sense, but in a legal sense, reinforcing contextual purposive construction. In US is what's the intent of Congress? So I think on top of the abuse analysis, on top of the factors of economic substance to indicate abuse, Parliament now reinforces it and saying, consider fairness of the system, maybe requiring a more serious contextual interpretation. Go beyond this provision, go beyond this word, like a Dean's Night. Look at the words as a proxy for legislative purpose, but not the whole. So through the GAR, the court can read in, like control doesn't mean de jure control, completely doesn't mean de facto control completely. It means something extra than de jure control, but not as much as de facto control. That's the beauty of the GAR.
So more uncertainty.
More uncertainty, so the balancing of fairness for all and fairness for one. So yes, so the judge have to do the real judging by comparing the values as broadcasted or embedded through the words in the legislation, not creating their personal values, what is fairness. So more serious statutory interpretation.
So the preamble, it strikes a balance. You see it as striking a balance in the fairness itself between the individual and the tax system as a whole, and striking a balance with the uncertainty to allow taxpayers to be able to arrange their affairs.
Yeah.
So
it's quite aspirational on the part of the Parliament. I don't know how judges will actually give meaning, give effect to that intention on the part of Parliament, but at least the desire is there. Yeah, not just certainty, because the Supreme Court has consistently placed fairness and certainty in one sentence before the word taxpayer. So it looks like it's fairness and certainty all for the taxpayer. The preamble tried to say, no, wait, what about the system? What about all the taxpayers in Canada? Okay. So I read that fairness that way.
And the preamble, it should be there to help interpret the GAR. And
it's a gentleman's reminder of how the judges should read.
So for every steps of GAR, so or only in the misuse or abuse.
Mostly the abuse, the misuse and abuse.
Because we go back to the intent of the legislation,
the purpose,
the purpose of the legislation, and all this. So, you have anything to add regarding the preamble? This is a new thing that we have. I don't know if it will bring more certainty or more uncertainty. It would certainly bring something different, but we will not know until a few years. Until a few years now. And uncertainty, you talked about certainty. I would just like to go back to that, because it is one big thing, one big argument from the taxpayer asking for more certainty in the Tax Act. We see it as a principle that always was there. I would see putting it in the preamble as making this principle even more important than it was. And I would agree with what you've said about where does the uncertainty come from? Does it come from those very sophisticated taxpayers that have very sophisticated tax planning, or does it come from the law, the application of the law? So we still have a long road to go through to make that more clear, more certain for the taxpayers. But I always think that the GAR, if the taxpayers can say, well, GAR is uncertain, and well, the whole law is uncertain, as you've said, the Income Tax Act is uncertain, but it's an argument that they are making, and I don't really see how it can be more certain, really, in fact. So I don't know how this argument that they are bringing forward, how it was really, it really influenced the interpretation of GAR prior to that. So I don't see if putting it in the preamble will change something in that. But as you've said, it's an intent of the Parliament that tells the judges, you should go and look at this through these lenses, or at least consider this balance that you have to strike between fairness and uncertainty. So,
yeah, maybe one point to add is the GAR itself is just a tool. The GAR itself has no meaning if we don't apply the tool to substantive provisions. So with the preamble, the economic substance test, the balancing of certainty and fairness is to say, how do we read Section 21C of the income tax, interest deduction? What is interest? What is reasonable rate? What is the income earning purpose? So GAR just now tell us, read the provision in context, in light of the purpose, and read the transaction. Is this transaction a real debt transaction, or is it disguised equity? And we look at the economic trappings, if the relationship of the two parties are in one economic family, husband and wife, parent company, subsidiary, no one cares whether they call the capitalization debt or equity, then why should tax law give so much respect to a legal form chosen that has no economic impact? Why should tax law respect it? So maybe now with the new revisions, and judges could look at transactions like TDL, like the interest deduction cases, and say, what is actually happening economically, not just on law, the form. So maybe those are the possible areas of change. In terms of the economic substance, or applying the preamble to the 5 existing Supreme Court decisions in the GAR, I cannot see it change the outcome of any of the decisions. And ultimately, I think Reuven emphasized in his talk, ultimately it is the intention and purpose of the legislature. So using Alter Energy, I guess people in the room know Alter Energy treaty shopping case. The Luxembourg Corporation, empty shell, everybody knows, this is not disputed. The taxpayer knew, this paper company, nobody know nothing. So no economic substance. If the GAR is applied today to the same facts, would the outcome be different? I would say no. Why? Because the majority's view of the purpose of Article 13.4, the carve-out, the purpose of that carve-out is to encourage investment in Canada. If that's the ultimate purpose, permitting taxpayers, American investor, to use a country everybody knows is so small, it doesn't have capital from its own people, and Luxembourg is known as an intermediary jurisdiction, the fact that Canada agreed with the Luxembourg government to have this treaty provision, to have this clause in, so if the court interpreted the intention is to encourage investment in Canada, no matter from where, whether it's coming from Luxembourg or US or Japan, it doesn't matter. So then permitting taxpayer structure to succeed is consistent with the policy and purpose of the treaty provision. In that case, economic substance is irrelevant. So at the end of the day, it is really what the legislature intended that provision to apply. So you could say the new preamble now says if the benefit is intended by Parliament, then it's not subject to the GAR. And treaty shopping benefit is intended because that's how the court interprets the intention of the treaty provision, and the court is supreme. The court's job under our constitution is to interpret the law. So the Parliament tried to tell them how to interpret the law. Ultimately, is the sole jurisdiction of the judges about how to interpret the law, and they interpret the provision to say encouraging investment is an important purpose, not stop treaty shopping. In that case, treaty shopping is fine.
Even worse, encouraging investment, but not even new investment.
Exactly.
It could be an existing investment.
Exactly.
That you just go through a different route.
Yeah, but investment, after all, if you look at the ultimate result, whether Alta investment came to Canada because of it, clearly not, because they didn't even use it. Yeah, but you can see judges still judge the way they wanted to judge, and the preamble, the GAR, try to provide some guidance, but
So what do you think, Rémi,
well, maybe just on the Alta point, I think if I remember, the facts were that the initial investment was not through Luxembourg. And
no, exactly.
Probably somebody at some point was like, well, we might want to sell this at a profit at some point, and somebody woke up and was like, oh, there's a way around it. And then it's like, oh, there's Luxembourg. But it just proves the point that you usually
that relates to something that I wanted to say about the way. So we've had in the US 2 big waves of tax shelters. One was in the 70s and early 80s, and the other one started just after that and went through about mid-2000s. And there's reasons to suspect that there's a third one happening now, and that's primarily because of tax realism, but we don't know yet because there aren't enough cases decided. But Liberty Global is telling. But the first wave was actually solved by Congress by there was a particular structure that was done, and Congress found the silver bullet and killed it. Although before it got to that one, it tried a couple of other things that did not work. But eventually it did, and a lot of people lost their jobs. That's one thing I always tell students: don't over-specialize in one particular kind of transaction and do it again and again and again, because it's not a good idea. This was just when I was beginning, and I saw a lot of people being fired. But the second one was not possible to kill it like that, the corporate way, because every transaction was adapted. It wasn't unique at all, but it was adapted to a particular class of taxpayers. So the transaction that I discussed, one of them was for a corporation that had capital gains, the other one was about a corporation that had excess foreign tax credits, et cetera, et cetera. So the way this was solved was actually by procedural means. Essentially what happened was that in 2003, there was a hearing in the Senate where the heads of the Big Four all testified, and they all disclosed that they all were devising these shelters, and in fact that they were migrating between one to another. And this was just after Andersen had collapsed, and they were all scared that there would be criminal proceedings against them. In fact, some people did face criminal proceedings. Individual partners at EY and KPMG went to jail over these shelters. But after that, what IRS did was that they put in procedural things against the advisors. So you couldn't give an opinion as a law firm without doing due diligence about the alleged purpose and that sort of stuff. And that actually worked. And I think that that's one way of looking at it. One thing that's really important for judges to realize is whether the transaction before them is just a transaction for one particular, that was engaged by one particular taxpayer, and the taxpayer came up with that themselves, or whether, like in the Liberty Global case, this was brought to them by Deloitte. And if you can discover that, and you can see that the same firm, the same accounting firm usually, because since they audit about a quarter of the corporation, they know exactly how many corporations are in a particular situation. When it's brought to the taxpayer from the outside by a promoter and the same cookie cutter is applied from one to another, I think that should make judges more inclined to apply the economic substance doctrine and doubt at least the subjective prong.
And the purpose of
Exactly.
getting into that transaction. If it's a transaction that was brought to you and it was not with a commercial purpose or an economic purpose that you were doing this and thinking about a reorganization or something and thinking about how we can do that the more tax efficient way, it's not the same thing. If someone tells you, oh, you should do that, you will save a lot of taxes. The purpose test is different. I think for those purposes.
So is the real solution that institution like Université de Sherbrooke should stop training like smart and creative tax lawyers? Is that the solution?
No. Smart and creative, but ethical.
That's
ethical
the point.
Students.
I have this infamous article that is entitled "Just Say No." What Reagan says, and basically what I said was, well, if somebody comes to you from the outside and tells you, "Let's do the transaction," and you both know that there's no non-tax purpose, you as a tax person inside the firm should say, "No, thank you." And some firms do that. Not every firm is a Liberty Global. I've known firms that have declined to engage in transactions. Even though it might benefit their shareholders in the sense that they will pay lower taxes. But, it varies from firm to firm, depending on the firm culture.
Yeah, some firms will apply the newspaper headline test. Can we defend that tax planning if we are on the big newspapers? And do we have a argument that we can bring and we can convince people that we were doing this for the right reason? But not everybody does that. And I think there is there may be a discrepancy between what the public is expecting and what can be brought, what can be challenged through a GAR or through an economic substance doctrine. There are cases that you would tell that to the general public, and they would say, well, it's not supposed to be working, this is nonsense. And well, when we apply those tests, we look at the purpose and the intent of the law and all this, and then we come up with decisions that make these planning okay. So other plannings emerge from these decisions.
Just to show you the complexity of things, Canada Trust Co's transaction was a well-known tax shelter, promoted and designed by some designers, and Canada Trust School adopted. But the Canadian Supreme Court said that's fine. It was one of the major cases that GAR wasn't found to apply. I was thinking about certainty. I heard from practitioners at conferences, now there's a practice of insurance. Yes. So these advisors have an indemnity clause, and now they buy insurance. So if they get audited by the CRA, GAR was invoked, and the taxpayer lose money, that money will be recovered from the insurance. So that's, I don't know whether that's a phenomenon of certainty or uncertainty. After all, it reminds us, tax is just a amount of money. It's just a bundle of money, whether the taxpayer keeps it, if it's a corporation, for the benefit of the shareholders, or the taxpayer pays the money to the government uses the money to pay for hospitals, universities, and roads. It's a bundle of money. So talking about certainty, values, and fairness, all of this, it's just $2 million to the taxpayer pay to the government, or to their advisors, or to their insurance companies, so that for a public company, they can manage the tax risk, how they can forecast, and how does that affect their overall position, so the shareholders, the stock market can have enough information to react to. So after all, it's just money.
How carefully does the insurance company evaluate the transaction before they decide to insure it? I guess that's the question.
Oh, yeah, exactly. A lot of work for the, I don't have the English word, you can help me with that, les actuaires.
Actuaries.
Actuaries, exactly. Yeah.
Any last thoughts on how the incorporation of economic substance in the analysis of misuse or abuse within the GAR can change what was done before? Because economic substance was not totally out of the analysis before. It was sometimes in some of the analysis. So how do you think this will change?
Well, I think it's going to be interesting to see. Obviously, like the main issue with the misuse or abuse analysis is this tension between trying to find the object's spirit and purpose, and this maybe like tendency to be like, well, it can be like what I think, a sort of smell test of like what I think the actual legislative purpose is. And so I think like courts in Canada really try to anchor the analysis and the words and the provisions and the scheme of the act. And this was an attempt to like prevent the smell test. Now that with economic substance, it's not clear to me if you get the same, I would say like, if you will be able to anchor it in the same like provision, because it's this additional thing you have to consider, and you have transactions that are economic, not that some others that are not economic. Like, how do you apply that? So it will be interesting to see.
Yeah, the way I understand the economic substance test in the new GAR environment is, I don't think it add too much weight to how judges interpret, judge facts, judge transactions, compared to the existing jurisprudence. So maybe I'm too cynical now, but I find Dean's Knight decision a functional equivalence approach to understanding the taxpayer's transactions, and say, not the legal form, not just the purpose. Yes, purpose, clearly you're doing this for tax purposes, but also looking at ownership of more than 50% of the voting rights. What is that purpose? The purpose is to enjoy the economic value of owning and controlling the corporate affairs, taking the reign of the corporation. That's the purpose of, under corporate law, owning the majority of voting rights. That's the de jure control test. So the Supreme Court majority in Dean's Knight said, well, in this transaction, it is investment contract, not corporate law, that gives the power and benefit in a realistic sense. It's through contractual arrangements with a dummy short-circuit minority shareholder holding company to break up the unanimous shareholder agreement in corporate law. But the Supreme Court said the functional equivalence of the investment contracts is to award this newcomer not to own more than 50% of voting rights, but enjoy all the economic benefits majority ownership rights will give to the owner. because of the preference shares ownership and the contractual terms. The new shareholder can dictate what the board do, what the board can decide. So that's what corporate control means. So now this, through contractual rights, the new person, Metco in the case, has all of these rights. So the Supreme Court said, functional equivalent, this different legal form, contractual rights, are treated the same as corporate law rights belonging to majority shareholders. So the GAR allows the court to look at, without going through the mechanical economic substance test, circular flows, and the statutory, the test in the GAR now is so mechanical. The three tests are cumulatively. So between paragraph B and C is and. You have to have the circular economic opportunity and third parties involvement and the purpose. How many transactions will meet that kind of test? So it's so narrow. So that's why I hope Dean's Knight is more influential, that because it gives the courts the flexibility of not following the test, but still finding abuse in the transactions by looking at really the function, the consequence of the transaction.
It's great. It's great that you clarify all the conditions are cumulative, so you need to have all of these. And if you get to demonstrate all these, this only tends to indicate that there is an abuse and misuse. So the test is difficult. So thank you very much. I will open to questions. If you have questions, yes.
Yeah, that's a great question. That's the biggest struggle in writing my paper.
Excuse me, Jinyan, just repeat the question because the audience did not hear you.
Oh, okay. Well, I can't really repeat verbatim, but the question basically is, I claim fairness has a legal meaning, not the moral, philosophical meaning. Where's the basis? How do you find it in the process? So the way I look at it is to look at the taxing provisions, the provisions of the statute that create tax liability, who, what, when, and stuff. So then I focus on income, and I look at fairness indicated by the choices in the legislation, like even with Section 2 sub 1, and Section 3, Section 4, Section 5 to Section 55. You look at these fundamental provisions, the statute is trying to measure income as ability to pay, as a proxy for ability to pay. So fairness as indicated in the legislative provision, meaning income has an economic sense. So at the end of the day, the economic substance, parliamentary contemplation, and the income is an economic concept. The Income Tax Act is a statute, a legislative articulation of arithmetics or economics. And so the fairness is reflecting fiscal economic sense, measuring everybody's ability to pay. So if a person has economic ability to pay, but through the legal maneuvering, making that ability disappear, that would be unfair. So the fairness is really derived from reading the provisions together to get a sense. In a way, it's like a global equity and triad JESCO kind of GAR cases. The court look at what does profit mean? And can you artificially create loss to wipe out your profit from other sources? So to me, that's the notion of fairness. Fairness emanated from reading the provisions together to get a more holistic sense.
Has this position been, let's say, expressed by a court so far?
No. That's why I think that's maybe the potential signaling effect of the preamble. There's traces where, like the two cases I mentioned, you can find traces. Court look at the Carter Commission, look at fairness, fairness based on ability to pay, like measuring the tax base. Yeah, so I think aggressive litigator on the government side may look at the why these provisions are enacted, using Dean's Knight, and say the words are expressions, but not the whole expression of rationale. So you look at the legislative history, you look at some general underlying principles, not moral values, right or wrong, not smell test, but principles that you can see from reading the act in a particular way, like keeping in mind the purpose of the statute, that you can tease out some principles. So it's very abstractive at this point. No clear case. So it's not a codification of a particular decision. Like the economic substance test is a clear codification approach to neutralize some phrases in kind of the trust code's decision, I think. But it's, the fairness thing is really, I think it goes back to Carter Commission, go back to in 1923, 1913, I guess, in US, Professors Seligman and these economists advocated, I would use the word, for income taxation because it's fair. Why income taxation is fair? So that's the origin of fairness. That then is get expressed in the complex statutes, but the idea, I would say the DNA was there from the beginning. It's just now buried by layers of layers of layers of wording. So the preamble may ask everybody to go to the root. Why do we have income tax? What does income mean? Why we could choose poll tax, we could choose property tax, but we chose income tax for over 100 years. Why? Because it is fair. Fair as expressed through the legislation. We tax every person every year, and that person's income roughly economic. Look at the employee benefit rules, shareholder benefit, all the attribution rules, all the shifting rules, and so there's an idea of fairness as a legal idea, not economic, not a moral idea. Yeah.
We have two questions online. One is from an esteemed colleague of us. So he's asking, I don't think, he's saying, I don't think it's cumulative, what we talked about, the factors. So maybe I put word in your mouth by saying it's cumulative. We'll have to see. Thank you for the question. We'll have to double check that.
You go back, pull out your slides.
Yeah, I cannot put it back.
Yeah.
But yeah, exactly. I wanted to go back, and I was looking if I had it here, but we will double check that.
Your colleague is not wrong in a way that in the Income Tax Act, when there are multiple paragraphs are used, the word or and may mean have a meaning that is interchangeable. So in some sections or subsections, and may mean or. So it's alternative.
Even so that is ambiguous?
It is. Even that is ambiguous. So in the context of the section 245 4.2, the word is clearly and. Whether that and can be interpreted to mean or, I don't know. But my reading is and. If I'm the Taxpayers' Council, I would argue and. Because that's what is unambiguous. So I have to have all three factors satisfied to fail that test. So that's why I think it's cumulative.
Okay, thank you very much. Another question on, I don't know if there's a question in the room. Oh, Eric.
How you think the judges will interpret the GAR if, in the end, there will be a penalty for the GAR? How will they feel that when you have a penalty, you know it's sanctioned, right? You sanction something, bad behavior or something like this, and it's so, like you said, ambiguous in the act. How can you impose a penalty, and how will it make a change in the judge's minding with the penalty?
Yeah, well, you're in the government. Well, you contemplate an official position. That's a great question. I think his voice is enough. Like we don't need to repeat the question.
Probably we have to repeat it.
No, the penalty, the impact of the penalty on judges' decisions in future GAR. It's hard to say. Judicial approach to tax avoidance, judicial attitude to tax avoidance is an area of study. There's some empirical research studying what makes a judge rule in favor of the government or in favor of the taxpayer, if the judge is Catholic or not. A judge used to be previous military, government official, a partner of a big tax firm. So whether they went to graduate school, all of this could have some impact. Now, having this penalty, I guess other jurisdictions may shed some light on the impact of a penalty on the GAR jurisprudence. As far as I could imagine, I don't think so, because the GAR penalty in the Canadian GAR is to match disclosure. So it is like a carrot and stick. The government needs transparency. The government needs to know what's happening. It's like the transfer pricing penalty. So in transfer pricing, the penalty is really an inducement for taxpayers to provide contemporaneous documentation. So basically telling the government everything, and it's up to the government to figure out whether they want to invoke the rule. So the GAR penalty may function more like that, like the transfer pricing, but it may have some impact. It's just hard to see.
I mean, the problem from my perspective is that in all of these cases, there were no penalties. And when there's no penalty, generally speaking, with large taxpayers, they can get more for their money in terms of interest or investment while they have it than the government's interest rate. And therefore, there's no downside whatsoever to engage in the transaction, because in the meantime, they don't pay. And by the time, if they have to pay with interest, they've, in the meantime, made more on that money. And so if there's no penalty, and also penalties have a shaming effect. Tax directors don't like being penalized. So, you know, I'm in favor of penalties, but we'll see.
Thank you. We will have to end it here, unless you have...
Oh, the official position.
Yeah, exactly.
Yes,
it's not an official position.
Official position. Just thinking back at we're talking about the US, but in the US, there are some penalties where if you get a tax opinion, it can shield you from certain penalties. So I don't know if maybe you could think of, well, maybe there's a penalty, some taxpayer will be more inclined to go see their tax advisor, as maybe there's a little bit of a self-policing that way. That doesn't really answer the judicial question, but maybe something.
That's a good point. Thank you. Thank you very much. We will have to end it here because we are at the end of our session. But thank you so much for accepting to be here. I think it was a great conversation that we've had. There's a lot more to say about this. We will hear about this for a long time, and then there will be the decisions that the judges will make, and we will discuss about these decisions and the modification that will come from there. Thank you very much. Merci beaucoup d'avoir été présent en personne. Merci aux gens en ligne. Puis, l'enregistrement va être disponible d'ici une semaine, quelque chose comme ça, donc pour les gens qui voudraient revoir certaines parties. Puis, je remercie aussi notre partenaire de diffusion, la PFF. Puis, je vous invite à nos prochains événements. Je n'ai pas la date du prochain événement en tête, mais surveillez le site de la Chaire pour les prochains événements. Merci beaucoup. Bonne fin de journée.